Welcome to LegalAF Midweek Edition with Michael Popok and Karen Friedman Agnifilo. On today's podcast, we're going to cover Trump two ways. He likes federal judges when he's trying to dismiss the Attorney General's prosecution of him or civil investigation of him, but he doesn't like them when he pulls a Clinton appointee in his big case down in Florida. We're going to talk about Steve Bannon and his latest ploy to avoid prosecution and the trial in July by filing, what else? A motion to dismiss. We'll talk about Marjorie Taylor Greene and KFA's prediction that went exactly to form, the federal judge sending it on to the North Carolina administrative process to decide whether she was an insurrectionist or wasn't, and whether she belongs on the ballot in the Northern District of Georgia. And we're going to end with one of our favorites, masks and vax. We're going to talk about the recent decision by the Middle District of Florida federal judge to say that masks are not really that sanitary, so the CDC doesn't have the power to enforce them on public transportation, and the Supreme Court coming back once again and saying that the commander-in-chief and in this case, the head of the Air Force can require its soldiers and enlisted personnel to get vaccinated in order as a condition of being in the military. And that's what we're going to do, Karen. What do you think about all that?
Exciting. It's really exciting.
It is exciting.
Can I start by complimenting your podcast this weekend with Ben, the big main legal AF? I listened. I didn't get a chance to watch it live, which I normally do, and chat with all the listeners, which I love doing, but I couldn't do it this weekend. It was, so many holidays. I'm Jewish, my husband's Catholic, so it just didn't work out this weekend. And, but I listened to it the next day, and it was one of the best podcasts I've ever listened to. And I really want to compliment you guys on how you handled all the issues and how excellent it was. And in particular, the Elon Musk Tesla, what you were saying about that and the way you described it, it was really fascinating and easy to understand. And despite the fact that we were criticized for our opening, which I didn't love, what was that about? There's some sort of
fake, phony, in good jest war between the two Legal AF podcasts, the one in midweek with you and me and the one on the weekend with Ben and me. And I took a pot shot. I thought it was funny. I think you did. A lot of the audience did. They noticed his collar was pointed in the wrong direction during one of the podcasts. And I made a comment about, you said how you complimented me, because that's the kind of people that you and me are, about whatever I was wearing that day. And I said, yeah, unfortunately, Ben hasn't gotten the memo because he looks like he pulls his clothes out of a hamper right before he podcasts on the weekend. He didn't like that. And he got back at me. It was great because I wasn't expecting it. He said, and Popok, what is with the opening that you and Karen are doing on the midweek edition?
I know. I was like, what?
I called him out. I said, this is obviously payback for the hamper comment. It's so obvious. But let me just say something about that. The show is the same. The focus is the same. The co-host and their chemistry are different. You and I have a different chemistry than Ben and me. And whereas he is like, even at 8 or 9 o'clock, whenever we do this, he's like a shot of tequila with a side order of cayenne pepper. We're more like smoldering aged bourbon or scotch. And so our opening is going to be different. Anyway, enough of all the logistics. Let's get down to the stories. And let's start with our favorite, Donald Trump. So I'll frame it and then I'm going to turn it over to you. We've got an attorney general in Letitia James, New York State Attorney General, who is leading a civil investigation of Donald Trump, Trump Organization, and all of his kids. And that's been going on for over a year. It's been supervised, if you will, by a state Supreme Court trial level judge in the state of New York the whole time. And everything is vetted with due process and adversarial process. Trump has the right. He has lawyers, and he makes his arguments to the state court judge. State court judge listens to them and then decides whether he's going to order depositions or order documents be produced or whatever it's going to be. So the whole process unlike what some people might think about, and you'll give your view of a prosecutor or an attorney general just running wild with all sorts of investigative techniques. This is going through a judge. Everything that Letitia James's team does is vetted ultimately and approved by a state Supreme Court justice. Well, Trump doesn't like how it's been going over the last year. So he and his lawyer of choice, Alina Habba, who's a New Jersey lawyer that works out of a WeWork or a Regency office, I'm not kidding, in New York, filed a federal case, made a federal case out of it in the Northern District of New York, because they got to find the furthest place from Manhattan they can go to try to hopefully find a conservative or Republican judge. Well, that didn't work because they got a judge, Barbara Sanis, who you may have been in front of before. I have, by remotely anyway, who's a Democratic appointee, and they file an injunction motion. Stop the state proceeding. Stop Letitia James. She's mean to us. This whole thing's a sham. We want to raise all sorts of constitutional issues. They filed that in December. This is now, let me check my watch. This is now April. The judge has not moved on the preliminary injunction papers at all. So they decided, why don't we write another letter to the judge? Never a wise move in a federal court, but that's what they decided to do. Let's do a letter motion and see if we can get the judge to move. And that's what they did. And so, Karen, what are they trying to do with this federal judge in relation to the state proceeding and the civil investigation?
So the theory I have is they're trying to basically knock Tish James, the attorney general, off the case. And that's sort of what I think they're trying to say, is that the state doesn't have jurisdiction, and she's the state attorney general, that it's really a federal matter and it belongs in federal court. And the question is, if that happens, will she be knocked off the case or not? Will she lose her jurisdiction? And at first, when I saw this, I had a kind of strong reaction thinking this is never going to fly. But then as I sort of read about it and read more into it, I remember when Cy Vance was seeking Trump's tax returns, and it was all part of a big subpoena compliance initiative. When they were basically looking into the Trump organization and the now prosecution of Weisselberg and the Trump organization. As part of that case, they were subpoenaing all sorts of documents, including the president's tax returns. And everybody knows that was a long, hard fought thing. But the state court judge in Manhattan was overseeing this subpoena compliance, much like the state court judge is overseeing the Tish James investigation. In our case, in the Cy Vance case, what the president did, President Trump at the time did, was bring a motion in federal court saying that this should be removed to federal court, that this is a matter of such great importance and it's a sitting president. And if you allow this to happen, every elected county prosecutor could go after every president. And, this just can't possibly be the case. And state court judges, many of them are elected. Many of them are Democrats, Republicans, political, this just opened up the floodgates for all presidents to be either sued or prosecuted all over the country, that this really belongs.
All sitting presidents.
Yes, exactly. That this really belongs in federal court. And in that case, the federal judge agreed and removed the case to just the subpoena compliance part of the case to federal court, and ultimately ruled that Trump had to turn over his tax returns. So, he ruled that it belonged federally. They appealed. The appellate courts ruled it belonged federally. They went to the Supreme Court of the United States that also said basically, yes, it belonged federally, and he had to turn over his tax returns. So it was a hard fought battle, but ultimately it stayed in federal court. And I think that's the precedent they're using to try to say.
They are. They're using U.S. versus Vance while you're in the office to say, see, a sitting president can't be subpoenaed or have a process against him led by a local investigative body. But what is the fly in that ointment, Karen?
He's no longer the sitting president.
Right. He's been out of office for a number of years. So I love when Alina Habba in her filing says, it's a great case, this U.S. versus Vance federal judge up in Northern District of New York. It has the same Trump. She actually said it's the same party there in one side of the case, and see what it says. And she leaves out completely the analysis of he's no longer the president.
It is, but yes, that's true. but it is don't forget, this was a joint investigation. This is a similar related case. So I'm a little bit I have pause. Let's just say, I don't think it's as clear cut staying in the state court as one might think, because it is related.
Can I ask you a question? Are we a little late to be trying to remove, if you will, to federal court? Didn't you waive this already? This investigation has been going on for over a year. She delivered preliminary findings, Tish James, like 3 months ago. He's been ordered by multiple courts to sit for deposition and produce documents. Are we a little late in the game to be arguing that the state court doesn't have jurisdiction over him?
Yeah, I don't know why they waited so long to bring this action. I really don't. Or maybe they just thought of it. Who knows? But I think they added in here that, Tish James is racist, and they're doing all kinds of all their old stops are coming out. So we'll see.
Yeah.
We'll see what they do. We'll see. I don't think it's going to go anywhere, but we'll see. We'll see what happens. But the open question I have is, if they decide it does belong in federal court, does that in fact divest Tish James of her jurisdiction, or can she bring this state court civil case in federal court? And that's the open question I have, that I was wondering what your thoughts are on that.
Well, people come here for the commentary and they stay for the predictions. So here's my prediction. This judge is not divesting the state court, Judge Ergeron or Tish James, of their jurisdiction over the former president of the United States about his business dealings having nothing to do with his time in office at all. And I think the reason we haven't heard about any decisions or any hearings or anything on the docket since they filed this BS case in December is because this judge is signaling, this is my interpretation, is signaling that she's really not interested in these issues, and she's got it on the slowest track possible, which drove them crazy. And I think that's what led to them submitting a supplemental brief. I don't think the judge asked for supplemental briefing. If I were the other side, I would move to strike the supplemental filing as being that's not in the federal rules. You get a round of briefing, but the federal rules don't have, when you're annoyed that the thing's not moving fast enough for you, you can file a letter brief with the judge asking them to move faster. That's not a thing. And so I think if I'm Tish James's office, I move to strike the letter brief and argue that it's improper procedurally. It should be ignored. And I don't think this motivates the judge one whit to move any faster on this. And when there's full briefing on whatever, I mean, I was going to say, I'll take you to lunch, but we go to lunch anyway. If I lose this one,
well,
I get the precedent. I get the precedent. So you asked me a question. I get the precedent. I don't think it applies. I don't think this judge is going to move on that. And I think Tish James is going to stay as the top sheriff in town when it comes to the civil side of the investigation of Donald Trump and his family.
Yeah, I think I agree with you, but it's a strange tactic that they're taking here, because if I were Trump and his lawyers, I would say to the state court judge, I have this motion pending in federal court. You can't do anything. And you have to wait until this judge rules before you can do anything, and just delay. I mean, that's Trump's tactic. He loves to delay. And I would think that in this particular instance, he'll also, if your prediction's right, he'll appeal, and then he'll go to the Supreme Court and delay, more delays. And all the while, everyone's frustrated and nothing can get done because the state court has to wait for this to weave its way through the federal court. So I'm surprised why Trump, given this delay tactic, and it seems that would benefit him, why would they poke the judge with this letter brief and their law-splaining?
Well, I totally agree with you. I think that's a very good observation, because as I've said on prior podcasts, Trump obviously subscribes to the old theorem: when bad things happen to you, make them happen slower. And that's what he's, because the time is on his side. He can maneuver better with a longer runway. But he's got a problem, right? That we've talked about in other podcasts. He's got a First Department state Court of Appeals case in New York about whether he has to sit for deposition. The judge Ergeron isn't waiting around to see what happens with the federal judge. That case got filed in December. The state court judge, has just been chopping wood since then. Trump, you sit for deposition. Trump, you pay $10,000 a day for documents. Let's take this up on appeal. Things are not stopping on the state side unless and until there's an injunction. And so I think he had to do something. This is being on the runaway train and like pulling the emergency brake and hoping that it stops. But I don't think it's stopping.
Yeah, I think you're probably right.
Yeah,
I think you're probably right. So as you were saying earlier, in this particular case, they love the feds and they want to move it to the feds. But then there's this other case, right? Go on. But you're about to talk about the other case.
They love the feds until they don't like the federal judge that were selected. Now, this one is a little bit closer and nearer and dearer to me because I actually practiced in this neck of the woods for 20 years, and I tried cases in front of Judge Middlebrooks, who's the judge that's been assigned the case in federal court, Southern District of Florida, by random assignment. Now, I will tell you, this is like the inside baseball stuff. Just to remind everybody, because sometimes you and I start talking in code and we don't bring everybody up to speed for LegalAF. About a month ago, Trump filed a lawsuit under the racketeering statute, the Rico statute, against Hillary Clinton, John Podesta, James Comey, and everybody else on his enemies list for the 2016 Russia interference conspiracy case that he says negatively impacted him. Pardon me. I will remind everybody that he won that election. That Hillary, if that's what she was trying to do, was to use the Russia investigation or an attack on him saying that he was in bed with the Russians to stop his being elected president. Newsflash, that did not win. That did not work. He was elected president. So what his damages are, other than legal fees, I have no idea. But it's another publicity stunt. And who are the lawyers? Alina Habba, who we just talked about, who's not admitted in Florida. So they needed a Florida lawyer. So who did they use? This guy named Tickton, who went to military academy in high school with Donald Trump.
Wow.
And he wrote a book. Like the real Donald Trump. So he has been, puckering up and kissing the backside of Donald Trump forever. And now he's got a chance to file the case, this big Rico case. So they're going to do it in South Florida because Tickton sits in Fort Lauderdale. Habba sits on the 19th hole of Bedminster Golf Course for the Trump family. So they say, okay, we're going to file down here. But of course, they look at the judges and they're like, well, wait a minute. A lot of them may not be in our favor, especially in Miami or especially in West Palm Beach. We're going to drive. You're going to love this because I've done this before. They're going to drive the filing or do it electronically now and file it in Fort Pierce. We'll take a moment for everybody to go look on the map to see where Fort Pierce, Florida is. It is the northernmost point of the Southern District of Florida district. It's the top of it. The bottom of it is Key West. The top of it is Fort Pierce. Why Fort Pierce? Because there's a lot of conservative judges up there. So they think. So they click the box for Fort Pierce. Trump, I don't even think Trump has a home anywhere near there. They think they're going to get a better lottery pick. Well, they spun the wheel and they didn't get a judge in Fort Pierce because the Southern District is one big mass of judges, and whoever's got time on their hands, they got Judge Middlebrooks. Why is that bad for them? Because he's a Clinton appointee. So Hillary Clinton, who's the defendant in the case, her husband 25 years ago appointed Don Middlebrooks, who was an amazing commercial litigator at a very good firm that I know in town, elevated him to the federal bench when he was like in his, I think, early 40s. He's now pushing senior status. I tried a case in front of him about 20 years ago. Really smart judge, unimpeachable in terms of ethics, has been sitting in West Palm Beach all this time. He gets the case. Okay, Rico. The defense is ready and like loaded for bear because A, they want to depose Trump because now he's a plaintiff. And B, they want to move to dismiss the case eventually because it's so ludicrous. Trump looks up and says, oh, crap, filing in Fort Pierce didn't work. I got the worst judge for this. So what do they do? Go ahead, Karen. What they do next?
Yeah, well, now they're trying to file a motion to recuse this judge, saying he can't possibly sit and hear this case, because whether or not he can be impartial, there's also a doctrine of the appearance of impartiality that needs to be upheld, and so that's what they're trying to do. I mean, look, whenever you try to forum shop like the way they did, sometimes it can backfire, and I always wonder if this happened on purpose, because it was so obvious they were forum shopping by going up to Fort Pierce, that they sort of, I'll volunteer, I'll do it, kind of thing with the judge. But who knows how that works? But go ahead. But the appearance.
No, I did something very similar. I'll be frank with the audience. I don't remember the case exactly, but I remember there was a reason we didn't want it in Miami, the filing. So we went to Fort Pierce, and I'm not kidding. I think we got Middlebrooks, because he sits in West Palm, but sometimes he goes up and sits at Fort Pierce. They sort of ride the circuit a little bit, but he already ruled. He's already, first of all, I don't know if you read the filing. And I mean, can the Trump organization hire lawyers that can file something that doesn't have typos in it? It was only a 5-page motion. And in paragraph 10, they spelled the judge's name wrong. Yeah. I mean, it's just mind-boggling.
It's recusal of a federal judge is very, very rare, right? I mean, have you ever seen it happen? Have you ever had it happen in a case?
I've tried once to have a state court judge down in Florida disqualified, and I got him disqualified, but he had a history of being disqualified by the appellate court. So I felt pretty good about that one, and he did some really bad things in the case. I've never moved to disqualify or recuse a federal judge. I never had to. Usually federal judges are beyond reproach. If they suspect that they've got a problem, like they own stock in the company, or a daughter clerked or did something with the law firm, they'll disclose it, and then they'll invite. Okay, I invite a motion to disqualify, because you have to do it promptly, and they'll sit back and let the parties do it. I had a case where I decided not to move to recuse. I'm handling a case in Chicago, in Illinois, on behalf of a litigant against a major Catholic university in the Midwest. Random wheel. I get a judge who graduated from what law school? The law school of the university that I'm suing. I had to make a judgment call. Do I move to disqualify him or recuse? And we did the research, and I did not have the grounds to do this. This was not enough. The fact that he went to that university without more, and there wasn't more, was not enough. So I raised the issue at a status conference, but I also closed it right down. And I said, Your Honor, I understand you went to that university, but we trust your ability. I figured I'd get a little mileage out of brown nosing him rather than moving to disqualify him. If they did the research, they would have revealed that just because Don Middlebrooks was appointed 25 years ago by Bill Clinton, every federal judge gets appointed by somebody. How many times have you and I talked about Trump appointees who handle Trump cases involving Donald Trump and cases involving his policies? They don't get disqualified. We'd like them to, but they don't get disqualified because he happened to be appointed by Donald Trump. We're going to talk next about the Florida mask federal judge. She's a Trump appointee.
Yes. Don't you think it's a little different? Let's say he had pulled a Trump appointee judge. Let's say it was somebody who he appointed. You don't think that judge might recuse themselves in a matter where Donald Trump is the plaintiff?
I don't know. I haven't seen it yet. I haven't seen one Trump judge walk away from something that touches on Trump. And the Supreme Court certainly doesn't do it.
Yeah, true. I just think that when you're the plaintiff, though, or the defendant, as opposed to one of your policies or one of your agencies, but when you're the plaintiff or the defendant, I wonder whether if you appointed that particular judge, whether that could potentially be an issue.
Yeah. You know what Don Middlebrooks said, Judge Middlebrooks said, and I think I liked it, and I think it applies to what you're asking. He said, federal judges must all transcend politics. And the fact that I was appointed, like every federal judge, is appointed by some president from some party without more, is not enough to find that there's an appearance of impropriety. Now, if there was more, like he golfed with the president, he went to wherever with Hillary on something, Hillary appointed him to some board or some charity, or the wives or the husbands have a relationship. But the problem is that plus more is missing in that. And I think it's missing. Yeah. It's probably missing in the example that you gave. Like, without more, the fact that, you know, that the person was appointed by Trump, I'm not sure that's enough. I mean,
I don't think it's enough. I don't think it's enough. And the other thing too, I've seen in both state and federal court, when there's a motion for recusal for one reason or another, and the judge chooses not to recuse themselves, sometimes I think they bend over backwards to make sure that they are fair to both sides. I really do think they make sure to protect the record, because now that's an issue. And so in some ways, just even raising the issue protects the record and makes it so that, and if this judge is as good as you say he is, I'm sure he will make sure that he calls balls and strikes and is fair and just.
He's going to dismiss that Rico case, but he's going to do it fairly and justly and after a lot of thought and pondering.
By the way, can we just talk about the fact that this case, I mean, forget the judge issue. Let's just talk about this case. I mean, Rico cases, you know, that stands for the racketeering, something corrupt. Yeah, corruption, you know.
Racketeering, influence, and corrupt organization.
Yes, I mean, it's what prosecutors use to prosecute the mafia, you know, for illegal organizations of, you know, these illegal sort of organizations that have a structure. They have to have a structure. They have to have like someone who's the head, and then they have to have like people, you know, who have hierarchy.
Capo regime.
Yeah, exactly. Right. But you think of Rico, you think of like I said, the mafia is certainly what I think of. And the fact that he's bringing a civil Rico case against his opponent, the Democratic Party, James Comey, he even threw in the Peter Strzok and that woman, I forgot her name.
And Debbie Wasserman Schultz.
Yeah, Debbie. Yeah, I mean, I was
Poor
like,
Debbie.
It's literally everyone he's ever had a beef with.
Yeah, it's his hit list.
Thrown in there, and it's his hit list, and then it's every single beef, every issue he's had. In like it's almost like a therapy session, you know, where he sort of just had to get it all out and get it all off his chest, and
he wants the judge to believe that John Podesta, James Comey, Hillary Clinton, Debbie Wasserman Schultz, and everybody else were all spokes around a wheel of a conspiracy working together to plot the Russian collusion case. And what's his damage?
Well, he said $24 million in legal fees to defend against the witch hunt, he says.
Hey, how about, all right, but you know what? Then if we're doing that accounting, A, wasn't damaged, he became president. B, how much has he fundraised? Exactly. How much money has he raised?
I'm sure he didn't pay a dime of that. I'm sure it was all this fundraising.
Exactly.
That he does.
And how much, and he has made multiples of the 24 million using the hoax, using the big lie, using the whatever to raise money. He does it at a whim. He blows his nose. He gets $5 million with we can't tweet anymore. Wherever he types up on a I almost said a rotary phone. He types up on a typewriter. Popok's losing it already. See, last week I wandered off without doing the third segment, and now I'm typing on a phone. I don't know what's happening here.
Okay.
Anyway, let's continue the thread of Trump appointed judges and what they're doing these days, and talk about Judge Carl Nichols, who was appointed by Trump in the DC circuit and is the judge presiding over the Steve Bannon trial that's going to trial in July. And as Ben and I talked about last year, there was going to be a motion to dismiss at some point filed by Bannon. I actually thought it was going to happen, and I want to get your prosecutor view. I thought it was going to happen a lot earlier. I thought he was going to get the indictment, and I think the feds thought it was going to happen a lot earlier because they're arguing waiver. You waited too late. He got indicted a long time ago. That's usually when you move to dismiss an indictment at the beginning or maybe soon thereafter, not like 3 months from trial. what is going on here? And what did the judge, a Trump appointee, what do you think the judge is going to rule about dismissing the indictment?
I mean, I have no idea what's going on. I can't possibly guess why they would wait so long. I mean, they waived that, but they also waived any objection to the privilege issues, et cetera, because they had to make those before Congress. This judge is saying, if you wanted to bring these issues forward, you had to bring these before Congress. And by not bringing these issues before Congress, you've waived them. And so it's not going to succeed here. But I don't know why they waited to do the motion to dismiss. It's very strange.
There's a lot of weird things coming out of the Bannon camp. I read yesterday that one of his new lawyers, you remember David Schoen? He's the Orthodox Jewish lawyer that argued against the impeachment on behalf of Trump.
Oh, right.
He came out 2 days ago in the media and said, if I were his lawyer then, I would have made him go in to testify to Congress, avoid contempt, but take the Fifth Amendment. So he's just publicly declaring that this was all a mistake. Now, what is Bannon left
look
with?
How many people have got in and given statements. I mean, so many people have gone in and spoken that he sort of missed the boat. I don't know.
And Bannon has now had one big part of his defense ripped away. I don't think we talked about it, but Ben and I did. 2 weeks ago, Judge Nichols took away a major defense that Bannon was relying on. He wanted to rely on what we call advice of counsel, that the reason, don't prosecute me, don't convict me. The reason I didn't appear before the committee is because I was given advice, good, bad, or indifferent, by lawyers that I followed. And the judge said, you know what? Under a 1962 precedent in DC Circuit, that is not a defense to criminal contempt of Congress. So you don't have that defense. Now, they're still tussling over some other defenses that they want to bring. But his big problem is he was not in the White House nor in the executive branch when all of the information that they're seeking happened. He was already citizen Steve Bannon, podcast host. He wasn't special advisor to the president at the time. So the fact that he keeps saying, but the president told me he was going to assert executive privilege. And I read a memo in the Department of Justice's own manual about people in the White House. Right. This is like the argument Haba is making about a sitting president who can't be prosecuted by a local prosecutor. Great. When you're the sitting president. Bannon is a podcast host at this point, and they narrowly tailored that subpoena to only go after things about Jan 6th, which is like 2 years after he left the White House. This is a dead bang loser. He goes down in flames in July. I don't know if he gets sentenced to the full 1 year, but he is going to prison, I believe, off of this. I don't know. I could be wrong. Maybe at the end, Nichols throws him, saves his butt. And I think this is a jury trial, don't you?
Yeah. I think so. I think for sure it's a jury trial.
What jury in DC is not going to convict Steve Bannon? Yeah.
Well, contempt he's not going to be tried for anything other than, did you go before, were you served properly? Did you know about it? And did you go? Did you not go? And so it's a very streamlined, straightforward case. And the Department of Justice prosecutors are making motions in limine, these pretrial motions, to preclude him from making certain arguments, from introducing certain internal memos, the ones you just said that he's saying he relied on, and they're making the necessary motions to say, you can't bring this stuff in. It's not the law. You can't just.
Let me ask you a question. Prosecutor question. Does he have to take the stand in his own defense in order to win? In other words, let me ask it another way. How does he avoid a conviction without taking the stand? Who's going to put on the evidence?
Well, it'll be interesting. So don't forget, the prosecutor still has to meet their burden and prove each and every element of contempt of Congress beyond a reasonable doubt. And let's say they put on members of Congress, which I'm sure they'll have to do, to talk about the fact that they why they wanted to have him come, that he had material information to provide, and that he was served properly, he didn't come, et cetera. And a good defense attorney is going to be able to potentially cross-examine these members of Congress and show their bias and show, et cetera, show kind of all the things that Trump's side of the aisle and Bannon, the witch hunt, and all of that's going to want to show. And there could be a jury nullification thing happen here, the way we saw with Gretchen Whitmer. None of us predicted that was going to be, that kidnapping plot was going to be not guilty. That was kind of ridiculous. But that was, I think, a jury nullification kind of case. And I think here you potentially, depending on, again, how the witnesses do, if he doesn't testify, that's always a question, that's always an issue. But that's how he would win without taking a stand.
Explain jury nullification, because we always like to bring up new lessons for the LegalAFers.
So jury nullification is basically when the jury decides on their own that they don't like a case, or that they think that a case doesn't meet its, you didn't meet your burden, but you did, but I don't like your case. So I don't like, or I don't like the law. I know, Judge, you're telling me that this is what the law is, but I don't like it. I think here it would be unfair, even though I think that the burden has been met and the elements have been satisfied. It would be unfair here for somebody to be convicted.
And they're not allowed to do that. Juries are not allowed. This is a bad thing, jury nullification. They're not supposed to do that.
They're not supposed to do it, but it happens. I mean, it does happen. And so I think that's potentially an issue. I mean, I think they'll prove their case beyond a reasonable doubt. But, you could always have one person or another who you could have. Don't forget, a jury has to be unanimous, right, to convict someone criminally. And you could always have someone who's a Trump sympathizer who's on that case, and who's going to be no matter what, I'll never convict somebody for this. I think it was a witch hunt, et cetera. And that's, so in that particular situation, you could have a hung jury, where you have a holdout or two or three, but you just never know. And of course, if he testifies, yes, he could assert all these defenses and say, give them something to hang their hat on, but don't forget there's cross-examination. And the cross-examination of Steve Bannon is something that you'd want to buy tickets to watch that. That's going to be well, one thing I'd like to do a little research on is I know in federal court, they used to pull the jury pool from the voter ranks. They do it now usually through the Department of Motor Vehicle. For the DC circuit, I assume that's the Department of Motor Vehicle in and around the District of Columbia. In other words, it's not Virginia, it's not Maryland, it's DC. And that is overwhelmingly a Democratic town. That urban center is very Democratic. I don't think he's going to get a jury of his peers. Fun fact. Every state has both federal prosecutors and local prosecutors, and the local prosecutors prosecute state court cases and the federal prosecutors prosecute federal crimes. DC is the only jurisdiction where the federal prosecutor actually does both, because it's not a state. They don't have a state prosecutor. So the Department of Justice there, the United States Attorney has basically two different divisions. There's the state court crime division, and then there's the federal court division. And anyway, it's just so in some ways, and the reason I bring that up is they're used to trying state court, just basically they know their jury pool. In other words, they're very aware of their jury pool, so they'll know how to pick a jury.
Yeah. This is I could talk with you about Bannon all night long, but we're going to move on to speaking of hopeless cases of racists. Let's talk about Marjorie Taylor Greene, this podcast's favorite congressperson in the Northern District of Georgia, who decides that she doesn't like the fact that the election board and the Secretary of State and the administrative process is evaluating whether she is qualified or is disabled under the 14th Amendment, Article 3, which is commonly referred to as the insurrectionist disability clause coming out of the Civil
clause
War.
None of us heard of until recently.
None of us heard of. And so she didn't like the fact that there was a petition to have her removed from the ballot. Now, let me tell everybody, she's on the absentee ballot that's printed, and it's already gone out, or it's about to go out. The primary is in May 24th. So there's a fight now to see if she's going to get pulled or yanked, penciled off. Now, let me just tell everybody, I'm not sure this matters at all, because I think that district votes for her nonetheless. Then there's going to be a fight about whether she gets seated or not. The Democrat is not winning. Now, maybe another Republican has to take her place, but the Democrat is not winning in a district that Trump won by 32 points. Okay. So a ham sandwich wearing a red cap would win that seat. Okay, if it went to that. So I don't want to get all excited, like, we're going to get that district. Democrats are not getting that district. The question is whether we have to put up with Marjorie Taylor Greene and all of her bizarre conduct and un-American conduct for the next 2 years or not. So she didn't like the fact that the state proceeding was moving along like a locomotive, overseen by Brad Raffensperger with a P, who is the Secretary of State that Trump called to say, hey, can you find me some votes among friends? She doesn't like that. Things are not going well for her. So she goes to, it's the court of choice for Republicans in trouble, federal court. Let me go do a federal injunction and try to stop that proceeding because I don't like the way it's going for me. And the wheel spins in the clerk's office. And who does she pull in the Northern District of Georgia?
Judge Totenberg.
Judge Totenberg, who's a Democrat. Well, I'm sorry, she was appointed by a Democrat. She probably is a Democrat. And so, she leafs through all of the case law and all of the things about the 14th Amendment. And she looks at the argument that she makes that she ripped off from Madison Cawthorn, which is that the 1872 Amnesty Act, which applied to Confederate members of the Confederacy, was a blanket pass forevermore for all insurrectionists in the future who now get a complete immunity in case they do anything wrong in the future. How could that possibly be? Fundamental.
How did the judge in the Cawthorn case say that a statute overrules an amendment to the Constitution? I mean, there's a hierarchy. We know that the Constitution
rock,
trumps,
paper, scissors.
Yes. I mean, how did they get to that?
And he's a former law professor. He got all tied up in knots with this language. There was a comma in the wrong place in the 1872 Act, so it must be prospective.
Even if the 1872 Act was meant to be prospective, doesn't the Constitution still trump that law? I still don't understand.
It does. You cannot.
Yes.
A session of Congress cannot, by law, by a statute, override a constitution. Only a constitutional amendment can override a constitutional amendment.
So that's what I didn't understand about that particular decision. Is even if you buy the errant comma and it's interpreted this way versus that way, even if doesn't it render it invalid because it's trumped by the Constitution? That's what I didn't understand. Here's
one for you that Judge Totenberg pointed out. If the 1872 Amnesty Act is a blanket removal of disability for everyone, notwithstanding the 14th Amendment of the Constitution, what do you make of the 1898 Amnesty Act? What was that for? Why did you need the 1898 Amnesty Act if the 1872 Amnesty Act took care of everything? They forgot about it when they did it. So the judge, in a 73-page decision, looked under a preliminary injunction standard, which means there's 4 prongs that have to be proven by Marjorie Taylor Greene, one of them being that she has a likelihood of success on the merits, that she's going to win at the trial of this matter on these issues. The judge says, let me see, what is it? First Amendment? No, you're not going to win on the First Amendment. You're on the ballot. And if we have to take you off the ballot, that's not First Amendment that you promoted the insurrection. What's your other argument? The 1872 Amnesty Act that was only applicable to Confederate soldiers and leaders? No, that's not applying to you in 2022, and so on and so forth. Now, this is interesting. in sort of the analysis that went forward. The next step now is not, I don't want people to take away from the federal judge's ruling, is not that Judge Totenberg has ruled that she's off the ballot. I want to tamp down a little bit the celebration. What she's ruled is she is not going to enjoin or stop or prevent the state proceeding at the administrative law judge level, state level, from continuing to evaluate whether Marjorie Taylor Greene is disabled. I mean that in the sense of not being able to be an elected official because she's an insurrectionist. Now, that's
on Friday, right?
That's on Friday. There's a state administrative judge
and
hearing.
She has to testify, right?
Well, I don't know. Does she? I mean, maybe there's just argument there, proffer that's made. But I have something for you, and I threw this out at Ben. I want to see your reaction. There are 800 people that have been prosecuted or in the course of being prosecuted for Jan 6th. You made a good comment a podcast or so ago about the nomenclature of the word insurrection and how it's taken on a life of its own. Not one of the 800 has been charged with insurrection. Not one. They've been charged with obstruction of a proceeding, which is a 20-year federal crime. They've been charged with seditious conspiracy, but not one of them, and there is an insurrection law in the books that they could be charged with. Does that matter if none of the people that actually took the torch and stormed the castle and tried to kill people and stop the peaceful transfer of power, if they haven't been charged with insurrection, is that a problem for this having the Marjorie Taylor Greenes removed from the ballot because they're insurrectionists?
I have a related point to your question, which is, doesn't Marjorie Taylor Greene have a sort of a due process right to be prosecuted and convicted of being an insurrectionist before she can be removed from the ballot? That's my biggest issue with this entire thing is I understand what you're asking about all the other people and they weren't even charged with that. And that could be, for all I know, there are elements of that crime that are more complicated than the crimes that these individuals were charged with. And it's more straightforward and it's easier to prove. And why give yourself a headache with 800 cases because you have to prove something that's harder to do, and perhaps being being charged with the crime of being an insurrectionist, that's harder to prove. So there are many reasons why a prosecutor may or may not charge that. But Marjorie Taylor Greene, so they have a hearing on Friday where she has to testify under oath about her involvement in January 6th, and she answers questions, whatever they are. But I just don't understand. Doesn't she have to be found guilty, or doesn't there have to be a finding of some sort of guilt of being of that in order to disqualify her?
Yeah, a finding, not of guilt, because of course that's the prosecutor criminal standard. This is a civil standard. So what Ben and I batted around like a badminton was:
is there a civil insurrection charge as well as a criminal? That's my question.
No, but the insurrection is not defined it doesn't say crime of insurrection. It says insurrection and rebellion in the 14th Amendment, Article 3. So yes, there has to be a finding made on some standard, some evidence standard. And it's going to be low. It's going to be preponderance of the evidence, not beyond a reasonable doubt, in front of this administrative law judge, this ALJ. And so they're going to put out, the people for the whatever. There's a whole group here that's been filing these complaints, and their lawyers are going to put on a whole slideshow, I'm sure, of her tweets. I know a little something about her Twitter account, having sued her successfully on behalf of MeidasTouch. So they're going to show her tweets, her public statements. I mean, there's no mind-mouth barrier with Marjorie Taylor Greene. It just comes spewing out. So there's a lot of stuff. They're going to have to choose. There's going to be too much. It's like a fire hose of stuff that she has said that paint her to be anti-republic, anti the democracy, an anti-American and an insurrectionist, and they're going to put up the best of. Here's the best 40 things that Marjorie Taylor Greene said about Jan 6th, promoting it, fomenting discontent, and painting it. And the judge is going to go, okay. And what's the standard I'm supposed to use for this? And they're going to say, well, here's the Merriam-Webster definition of it. You're going to see it. And don't don't laugh. Our audience don't laugh, because judges often use, as do lawyers, when they can't figure out what something means, they'll go take the Merriam-Webster or the Oxford Dictionary definition of something and argue that it applies. Look, we're going to talk about the mask ruling by the Middle District of Florida judge. At one point, she said, I went to the corpus linguistics to find out the meaning of the word sanitary. You and I call that Googling. She Googled. She gave it this great term I had never heard of, about searching in databases for common usage of words. So you Googled it. All right, Judge, I get it. And to say what this word meant or didn't mean in the statute. This judge, this administrative law judge, I am sure is going to be hard on the plaintiff and say, what is the standard I am supposed to use to decide whether, like you just said, she is an insurrectionist? You're not coming here with, Judge, we got a conviction. Here it is. She's convicted. Take her off the ballot. That's easy. This is hard.
Yes.
So
that's what I think.
Yeah. I'm not sure she gets.
Yeah, exactly. I don't think she gets booted.
I don't either. And I think we're going to have to vote for her or not vote for her. The ballot box is going to have to decide whether Marjorie Taylor Greene is going to be a member of Congress or not. I know that's not going to satisfy, and people are going to be upset during tonight's live chat, but we're not here to blow smoke or sunshine. We're here to tell you the truth as best as we analyze it. Let's move on. We'll do the last one. Let's just do, why don't we do masks? Because, everybody was all upset about it. And boy, the airlines couldn't wait to implement the new rule. They one pilot for, I think, Alaska Airlines got on the microphone. Can you imagine this? You're already freaked out being on planes these days to begin with. And the captain gets on and goes, this is your captain. I am about to make the most momentous announcement of he actually said this, my entire career. Okay, when I'm sitting there with like my little mini bottle of scotch or bourbon, and I'm on a flight, I don't want to hear the captain say that. And when he said next,
unless it's I won the lotto or something, and I'm sharing with all of you,
or we're getting in 20 minutes early, then I'd be really excited. But what he said next was, you may now drop your masks. I'm like, oh, really? Seriously? So here's what happened. A group of concerned citizens and air travelers filed a lawsuit because the Biden administration and their CDC, the Center for Disease Control, extended the mask mandate in light of the new B2 variant, whatever it is, until they got the handle on the science. They said, you know what? We were going to let it expire on April, 14th. Let's let it go for 2 more weeks. In the meantime, this lawsuit's been going on about the fact that the CDC may have exceeded its powers because and I agree with this, every agency is a creature of statute, is a creature of legislative history, and a creature of what powers have been delegated to it by Congress. I totally agree with the judge on that point. So they run into court. Judge, the mask mandate is beyond the powers of the CDC. They don't have despite their name, Centers for Disease Control. Sorry. They don't have the right to control disease and come up with a method to stop the spread of the most infectious disease in our lifetime, COVID. Okay. And all right. So they go and they use the same case law that they were successful in getting when the CDC had the eviction moratorium. Even the Supreme Court said, you know what? There's a bunch of things you can do, fumigation, pest control, throwing out mattresses, rent eviction is not one of the things the CDC can do. And I was okay with that because I thought it was a stretch. But prevention of disease by transmission and requiring masks, I did not think this was a problem. So they spin the wheel. We're talking about the wheel a lot tonight. And they get a newbie. They get a federal judge who's 37 years old, who spent less than 6 months in private practice as a lawyer, Her entire time, like she was hermetically sealed from the time she graduated law school. She never saw the light of day. She did one federal clerkship after another federal clerkship until she got to Clarence Thomas at the Supreme Court level. So she never saw the light of day as a practicing a lawyer. She never went to court. She never tried a case. She never second chaired a case. She never handed papers to the person trying a case. Never, nothing. But Trump thought, hey, here's an 8-year lawyer. We can appoint her as a federal judge. So this federal judge, Catherine Kimball Mizell, is the judge. She writes a very detailed opinion, which, Karen, why don't you explain why this federal judge believes it's beyond the CDC's powers to mandate masks in public transportation?
So she said, this is a long ruling. I think it was like 60 pages long or so. But basically, she turned to the meaning of sanitation because, basically, the federal government in regulating disease can regulate sanitation. And she said the way she defined sanitation was it has to sanitize or clean, and wearing a mask does not clean something, which I actually think it does. It actually cleans the air that you're breathing out or breathing in. But for whatever reason, she doesn't think that was within the definition of sanitation. And the reason that's relevant is in the rulemaking, that the CDC is allowed to do. That's one of the things that they're allowed to do is things involving sanitation. The other issue that she sort of talked about was, there is a right to travel in the Constitution of, the sort of constitutional right to travel, and there are limits on how you can restrict people's, laws that restrict people's travel. And she said that some people have to travel, whether it's for work or for other reasons, and that this basically restricts that and violates the Administrative Procedures Act and violates the law. And that's why she knocked it down.
Is the right to travel embedded in the Commerce Clause? Is that what we're talking about?
I think so.
Yeah.
I only know that this exists because there were times when I was a prosecutor when we had sex offenders, for example, and we wanted to ban them from the subway, and because you had these serial gropers who would rub up against in New York City, the subways are very, very, very tight, and sometimes you're almost pressed up against someone. Obviously, this is mostly pre-COVID. The idea of someone breathing in your face today, at rush hours is almost incomprehensible. But for many, many years, you'd be pressed up like sardines in the subway with people, and you had these serial sex offender gropers, subway gropers, who are just beyond disgusting. And you'd have people with multiple offenses and convictions. And there came a point where we wanted to ban them from the subway, and the really smart lawyers who advise you on what you can and cannot do in matters such as this said we can't because of the constitutional right to travel. You couldn't restrict their ability to travel, and they had a right to do it. So it was just sort of an interesting point that she made and how she looked at it. I think it's completely wrong. I think it's ridiculous. What I didn't understand was she's just one judge in Florida. How does she get to order the entire CDC for the entire United States of America? How did that work?
Yeah.
That the minute she ruled, nobody appealed, nobody said I'm going to go to another judge. Nobody did anything other than I'm not enforcing this. And here's what happens. I think federal judges have powers that go beyond their jurisdiction when it comes to constitutional or statutory analysis, unless and until another federal judge comes up with a counter position or a different ruling, and then that split in the circuit or the split in the law. Until there's another federal judge that rules somewhere in a different circuit or a different court, that federal ruling is the only federal ruling on the issue, and has, as you just noted, sort of extensive powers around the 50 states until somebody else, if we got let's say next week,
a judge in New York said, that's ridiculous. Sort of like what we're watching with the Marjorie Taylor Greene and Madison Cawthorn. But until there's a competing decision, that is the decision about it by a federal judge. Now, here's my problem. I read the order. This is an example of reverse engineering. She wanted to get rid of the mask mandate. So she went through trying to find some word, some grammar, some punctuation buried somewhere, anywhere in the statute. And when she didn't like something, or it didn't fit her reverse engineering, she threw it out or ignored it. For instance, rather than go back to the legislative history around the statute, which is a proper statutory technique to interpret a statute and its meaning, is to go back to see what the framers, what the sponsors of the bill, what the debate was around the bill. That's all reported in the congressional record. It's right there for her clerks to go find. Rather than do that, she Googled what the word sanitary means.
And, why would she even have to Google it? Shouldn't the party's papers, the government here saying that it's the CDC, shouldn't they put the legislative history in their moving papers and spoon feed her the law? But she ignored it. She ignored it. Yeah. She
went to her toolbox. She said, what's this one? Legislative history? Nope, don't want that one. What's this one? A word in the Merriam-Webster dictionary. And then I'll do that. Okay. So, a lot of times, as you know, federal judges, even state court judges, they sometimes lift their entire decision out of the other, one brief or the other, or they just go, no, I'm going to do my own thing. So she ignored legislative history. She ignored plain meaning of the word sanitary and sanitation. Do you know what a surgical mask is technically called? It's called a sanitary face covering.
I didn't know that. Wow.
Yes, the word sanitary is used. She said, oh no, see, a mask is not sanitary. Now she's a scientist because it captures droplets. And who is it sanitary for? I'm like, are you kidding me with this pseudoscience bullshit?
This is a absolutely bizarre and wrong ruling, which leads me to believe some other judge tomorrow or next week is going to rule differently. And then what? What happens? Who controls the TSA? No, but in the meantime.
But here's the problem. And this is what I don't understand. Why did the Biden administration just lay down?
Yeah.
Why did they walk away?
I don't know.
Rather than do are they just tired of taking their lumps on masks at the Supreme Court level? Oh, they've won a couple. Look, they've had 10 or 12 cases already. They know where the Supreme Court is sitting. If it's vaccines, they got a decent shot, depending upon whether there's a military overlay to it. If it's churches, they don't. If it's masks.
I think they know that masks aren't long for this world anyway. They were about to let it expire and they extended it a little bit. I think they just said enough. People have grown mask weary. People are getting their second booster. I think they just said, we're done. And I don't think there's any going back. I think people I agree with you. People have mask fatigue. And I also think that we haven't done a good job at being consistent. You've got some people who don't have to wear masks indoors, other people do, and it's caused a lot of fatigue and confusion. I think people have just had it.
Yeah, I totally agree with you. I think the Biden administration has made a political call that they were going to let it expire anyway, and they don't want to make more bad law on their watch that other presidents, maybe this one, and if he's reelected, have to live with. Every time you go knock on the door of the Supreme Court, you have a chance to make good law that you like, or you can get beaten with both ends of the stick and end up with bad law that you have forever, because, I used to say forever because precedent lasted a long time. It doesn't last a long time with the current makeup of the Supreme Court. They're like, when did we last make that decision? 4 years ago? Let's bring it back up and do it again because now we've got the numbers. I mean, it's disheartening and ridiculous. But Karen, we've reached the end of another midweek edition of Legal AF. It is my favorite time during the week. Don't tell Ben. It might have to do with how you dress. I think it's always immaculate and perfect and great, and I enjoy my time with you. So any concluding words or parting words before we sign off for tonight?
None actually. No concluding words for tonight.
Pass.
I'm gonna take a pass. Yeah, my only parting words are, I like our beginning. We don't need to have that big dramatic beginning that,
Yeah, he likes to wake the dead for the beginning of it. And you know what? That's a new thing he's been doing anyway. We didn't originally do that. If you go back to older episodes of the pod, that's become a new thing. And
what we have to do? We have to put together, somebody who's listening to this, who's really good at this, has to put together like the best of Ben's intros, yes, all from like the beginning, and then sort of the crescendo of the shouting at the end. And I bet it would be hilarious. Absolutely hilarious.
All right. I'm somebody out there, and I can think of a few people that are good at this. Put together a compilation, best of Ben openings and closings for LegalAF over time, and we'll run it somewhere. So one of us will run it.
It'll be hilarious because you'll see the buildup, right, and the fact that he's sort of changed. You'll see the athletic greens sort of take hold, and now he's got so much more energy.
Yeah. We'll see. And also, let's be frank, and then we'll end it on this. I'm on, I don't know, episode 60 with Ben. You and I have been doing this 14 episodes, 15 episodes. And I think I don't know, I like to think we're improving every time. I try to.
Me too. I think we are.
I think we are. All right. And anyway, we'll let everybody in the live chat tonight tell us whether they think we are. And we'll look forward to next week. Shout out to the Meidas Mighty and the LegalAFers and the K fans.
Take care.
So long. Bye.
Bye-bye.